You know, with the arrival of 2013, a lot of changes have taken place in the law. And among those changes are the change to the estate tax. And in this segment, we're going to look at how it affects you. Now, there are a number of provisions in the new law that positively impact the way you can plan and the way you can look over the horizon for your heirs. Let's take a look at how it affects you. Now, under the previous version of the estate and gift tax law, the changes were coming about almost every year, and it was not permanent with a sunset provision built in. But the new estate and gift tax law gives us permanency that allows us to plan much better. Now, without the new law, the exemption that was in place would have expired on December 31st, 2012, and then in 2013, the law would go all the way back to its level in 2003, which was $1 million. Last-minute negotiations and last-minute passage of the new law allows a greater degree of flexibility, and that's what we have today. Now, it is true that the tax rate did go up to 40%, but that is still better than what it was in the last decade when it was as high as 55%. Now, the other good news is that the new tax law did in fact unify both the gift and estate tax under the same level, meaning that we can either give away during our lifetime or pass to our heirs at death the same amount, which is $5.25 million. Now, under the previous version of the law, if you had a married couple and they had an exemption amount for each of them, at the death of one, that exemption amount was either used up or it was gone forever. Under the new version of the estate tax law, we finally have got portability, meaning that the amount that's not used up by one spouse at their death can be passed on to the other spouse to be used up at that spouse's death, combining the two for a greater total. That's very good news. Now, if you have a living trust in place, you may want to talk with your estate planning lawyer about updating and amending your trust to take advantage of the new rule. Now, in the current economy with low interest rates, the use of grantor retained annuity trusts, or GRATs as they are called, did have some possibilities of limitation. But under the new rules, they don't. The restrictions have been removed, and that does provide for the possibility of a tax-free inheritance. Now, while this new estate tax law does give us certainty that we didn't have before, it's not going to last forever, because one thing that's always certain, if Congress is in session, your tax write-offs and deductions and exemptions and allowances are always at some risk of change. So therefore, we should never be complacent about good proactive planning. Proactive planning can go a long way. I'm attorney Michael Potter, and I look forward to hearing from you.